Two cases before the U.S. Supreme Court, one slanted in the direction of trademark, the other dressed up for copyright protection. Both will tell us a lot about the bounds of commercial free speech. Gina Passarella has this.
Sorry if I know it's too sharp. Sorry if our voice is too raw. Don't make the pen a weapon and censor our intelligence until our thoughts mean nothing at all.
How did the slants
Sorry if you take offense.
wind up on the steps of the Supreme Court? Because the government denied a trademark for their name under a law known as the Lanham Act.
It allows the Patent and Trademark Office to prevent registration of immoral, scandalous, disparaging marks, and it also has provisions for marks that might deceive the public. And in this particular case, they made the judgment that the slants, the name of a particular band, was disparaging of Asian people.
But for Simon Tam, bass player and spokesperson for the Slants, it's always been about reappropriation, taking a slur about Asian Americans and reclaiming it as their own with cultural pride.
Whenever you Googled slant or slants, the top hits all on Google for the first 4 pages were all to white supremacist websites. And now it's to a rock and roll band that proudly shares its heritage, and I think that is super cool.
And now it's up to the nation's highest court. And although the Slants case looks promising, there are no guarantees. The government wants to prevent registration of the most vile racial epithets and messages, and to disassociate itself from speech it finds odious. Case in point, the intellectual property highway is littered with thousands of so-called disparaging names denied trademark protection.
That's one of the arguments of the Trademark Office, is that we're not preventing you from using the slants or Redskins. You can still do that. You just can't register it with the United States Patent and Trademark Office.
But getting a registered trademark is a highly valuable business asset, a notion often lost on young members of rock bands. Roger Stevens, founding member of Blind Melon and an attorney with the Ballard Spahr law firm, provides a cautionary tale from his early days with the band.
In rural Mississippi, not too many people are trademarking stuff, so it never came up. But I would advise people to think about it early on, because by the time we really got down to dealing with it, we had already started selling records and money was coming in and nobody knew what to do about it. We had some imagery that was the B-girl, for example. It was popular and somebody was making money off of it. We had not trademarked that image or the name from what I understand, until later.
The Slants now hope their betting everything on the First Amendment argument will get them their trademark. And they aren't the only ones betting on the outcome. The Washington Redskins, whose canceled trademark is tied up in the courts, believe their rights will be restored if the Slants prevail.
So I think these are old provisions of the Lanham Act that are archaic, out of date, and should be thrown out completely.
If the government truly cared about fighting racist messages, they would have canceled the registrations for numerous white supremacist groups before they even approached our case.
By granting the Slants a forum, the U.S. Supreme Court is putting the First Amendment and the U.S. government's right to restrict trademarks in the spotlight, raising the question of whether the government is up to the task of deciding what is disparaging or immoral. For the American Law Journal, I'm Gina Passarella.